And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
Well, not may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
साहब यही तो पॉइंट है कि एक तरफ आप कह रहे हैं हम राइट ऑफ अपील दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो फुल कोर्ट बन जाए तो बन जाए.
फुल कोर्ट बन जाए. मैं ये कह रहा हूँ कि there might be issues in time.
आप काइंडली जरा थोड़ी सी
नहीं मैं there might be issues in time.
Applications of your submission तो काइंडली देखिए.
मैं उसको ये इस तरह से आपको कहता हूँ कि
Attorney General साहब, let's be, we are all grown ups, right?
Attorney General साहब,
can I just the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did Rekodik. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary. They'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that they did what they thought at the time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस लेजिस्लेशन की भी जरूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा प्रॉब्लम ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं. मान लें गलतियां हुई हैं, ठीक है. हमने ऐसी ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को. मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जज में लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. द मिनट आई से दैट प्लीज फाइल अ रेफरेंस अगेंस्ट मी दैट आई एम वायलेटिंग माय ओथ ऑफ ऑफिस इफ आई से इवन दिस कि आई विल एंडोर्स दीज सब्सिक्वेंट एक्ट्स. मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिक्र पड़ी. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 पिटिशंस आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं. वो कहते हैं हमारा केस चला के खत्म कर लें. सॉरी आई एम डाइवर्जिंग, बट we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. But what are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें Attorney General साहब, Attorney General साहब, Law Reforms Ordinance के तहत there's a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches, and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है, 184.3 is discretionary. Now, यहाँ पे जितनी बात हुई, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
ये जैसा एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज हैं, वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This will just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section 7.
Provision of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to
देखिए
see
हम सारी बात चले ठीक है, मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? वी द होल विल बी गटेड.
how many cases would there be, my
And no limitation period is
ये
here.
तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been what the parliament has,
चलो ठीक
my
है.
lord, what the parliament has tried to address here is
So you see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185 73 से शुरू हो जाएंगे.
my lord 1947 तो नहीं 75 पे पहला हुआ था.
एक बात है, आप इसमें
88
is
में आ गया
open-ended
था
ना.
दूसरा, and then
You have fixed a limitation of 30 days. This act means all previous decisions within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद
law was
अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड. ओके
couldn't have taken effect.
फिर एक और छूट जाएगा ना. ये बताइए, जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया, कैन द पीपल ऑफ दिस कंट्री फाइल अपील्स एंड have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
And
we
my lord,
fear
just
if
to-
it's
Quick
Otherwise,
history,
we'll
I
be brushing
think
things under the mat.
1975 Manzoor Ilahi was the first case under 184(3), and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps
But where
पिछले
do you
15
draw the
साल में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be.
Let it
Why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because everybody's dead or whatever, long past. Gone.
my lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail
ये section 6 पे भी बता दीजिए, Learned Attorney General,
My
ये
lord.
जो आपका
Right
right
to
to
counsel.
Yes, because it
Now-
is already covered under Article 188 of the Constitution.
उसमें order 26 है.
Power of the review.
जी, order
So you
26
have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा my lord का 188 पढ़ लें जो refer कर रहे हैं my lord.
188 is the Supreme Court shall
हाँ पढ़ लें जरा.
have power
subject to the provisions of any act of parliament and of any rules made by the Supreme Court, to review any judgment pronounced or any order made by it.
Yes.
So this power, under the power of review,
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ
bound by the Supreme Court rules, or rules are an aid of administration of justice, and rules bind the council and the litigants but does not bind the court. What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and council, but there may be cases of extreme injustice where we may overlook. For instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided that it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us not really
That's what-
bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
वो एक
that,
overall है.
It says that the rules shall, nothing in these rules shall be deemed to limit or otherwise affect the
At
inherent
the
powers
end
of the
day,
court.
it's not so important,
It's practice and
significant
procedure, my
document.
lord. It is
Huh?
practice and procedure. These are all.
और वो भी हमने
procedural
order
in nature.
47 को connect कर दिया and civil proceedings, civil procedure court के साथ. So these are not, I mean, these are not like ironclad things that we cannot, we'll see where the justice of the cause lies, and of course, it doesn't mean they're totally irrelevant, so we will see when it's appropriate. It may be a good case, it may be a bad case, I don't know. So आपका, you conclude या कुछ और रह गया
My
आपका?
lord, I have
Mr.
concluded.
Attorney General, if I
In
may ask a
writing,
question,
I mean,
if I may ask a question.
Well,
If you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
Then these rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
my lord, my response to that would be that both the preamble from which we draw those salient features.
No, I think the thing is
The
that when
independence
the
of-
Supreme Court is sitting as a court of law, what is it bound by? If it's not even bound by its own rules, why should it be bound by an act of parliament?
My lord, the
We can
rules,
say then
the
maybe-
rules, the
then
rules
maybe
say.
that particular bench can say, well, we don't recognize section, what is it, section 6? And another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your, this law that you're defending,
I think the
not
rule,
that be put in the same category vis-a-vis our own rules? If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number 1 is constitution. Number 2 in scale of importance is law. Number 3 is rules, then come regulations, then come notifications, then come whatever you want to, instructions. So this is, in my mind, I go by that approach. I may be wrong.
my lord, the rules, actually, Rule 6 of Order 33 itself.
वो तो खुद ही
acknowledges
कहता
that.
है।
I
वो
think
खुद
the
कह रहा है
Constitution
कि
actually
abuse of
mandates-
process नहीं होगी, ends of justice को meet करने के लिए अब you're not bound by.
Attorney General,
that
the
extent.
rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we bound by them.
And
they might be in the trajectory starting with the Constitution, law and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on the basis of it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where relying upon Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So when the preamble, when the Constitution was being made, 199 has not undergone any amendment ever since. So therefore, my lord, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect. And nothing in this act in any way undermines the independence of judiciary or nor has any externality been introduced where any other organ of the state or branch of government has been given any role whatsoever.
Hopefully,
Grateful, my
these
lord.
are your final words. Hopefully.
Attorney General sir,
I'm going to have that answer.
Attorney General sir,
My lord.
आपने कंक्लूड तो कर लिया, बस एक क्वेश्चन पूछना था कि अगर फर्ज करिए कभी इसको हम अल्ट्रा वायलेंस डिक्लेयर कर देते तो बात खत्म हो, लेकिन अगर इसको हम कहते हैं कि वैलिड लॉ है, वैलिड लॉ हो जाएगा वहां से जब ये बना था, इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस?
My lord,
अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा इसके
lord,
बारे में आप बता दें।
they become past and closed transactions in several instances in the past where a similar situation or a situation arisen where legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions. So that would be the effect to matters which stood decide. Which
Can the
stand
committee
decided.
not retrospectively, suppose if the law is sustained, Can the committee not retrospectively grant permission? The bench was constituted,
My lord,
assumed as if by
lord,
consent.
the cases-
Let's put it like that. I don't know if that's
cases
possible or
which
not.
stand decided, they stand decided.
नहीं,
And
अगर
that extent
अगर
is
हम ये
past
भी
and
कर
closed.
लें कि अगर कोई बहुत ही ऐसा unusual केस आ जाए, I don't know.
My lord, I don't know where the line would be drawn, but
अगर आपको
in so
जितने
far
note,
as,
I think
जी मैं इसको भी एड्रेस कर दूंगा, but
ड्यूरिंग
जो
द
केस
पीरियड की बात हो रही है ना,
जो
इस
cases
दौरान
के-
इस दौरान जो हुए फैसले हो
जी।
गए उनका क्या बनेगा?
सो जो केसेस लिस्ट अब पेंडिंग नहीं है और वो डिसाइड हो गए हैं केसेस
During this period.
जी ड्यूरिंग दिस पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए
इतना पास नहीं हुआ, अभी कई बात है।
वो आई थिंक दैट इज समथिंग दैट माय
उसमें
लॉर्ड
तो
वुड हैव टू
दो चीजें हो
सी इफ
सकती
माय
हैं।
लॉर्ड विश टू प्रोटेक्ट
good
देम इन द
lawyer
पास्ट एंड
thinks of
क्लोज
all the angles. This
उसमें
is
दो चीजें-
possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं। एक तो डिफेक्टो डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील प्रोवाइड हो जाएगी, सो दे कैन जिनके भी
as far as 184.3 is concerned उसकी होगी, जिनकी नहीं थी 184.3 वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात, उसमें आप देख सकते हैं कि वो तो मेरे
It
जुडिशियल
won't be a classic. देखिए दो किस्म के होते हैं, एक होता है classic quorum non judice. ठीक है, this won't fall in that category. It will be simply a procedural lapse. Whether a procedural lapse will affect the outcome.
lord, the cases which stand
I don't know.
if I may be,
क्योंकि एक तो होता है ना substantive right किसी की गई, बोले आपका क्या right किया?
वो डिसाइड हो गए केसेस, वो पास्ट एंड
नहीं
क्लोज
नहीं, पास एंड क्लोज का लफ्ज क्या अगर हम
या,
कहें,
आप-
देखिए एक होती है यू सब सब्सटेंटिव राइट हैज बीन टेकन अवे, भाई ओके दिस थ्री डिडंट हियर इट, दोस थ्री हर्ड इट, आपको क्या फर्क पड़ रहा है इससे? अब आर यू विद मी?
जी, जी।
सो आई एम जस्ट थिंकिंग अलाउड.
Understood. So it does not, let's say, there is no, it's substantially कोई offend नहीं किया किसी right को, कोई, it was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे, वो रिव्यू तो पड़ा हुआ है फिर भी, और ये अपील पड़ी हुई है 184 में,
Yeah.
तो
जी.
पता नहीं
And in any
हजारों
event,
cases
I mean,
decide
it
हो
was a
गए
bench
हैं.
comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा? चलो आपने मेरा अदालत में सुन लिया या सरदार साहब की अदालत में सुन लिया,
Members of the
कोर्ट
Supreme
तो
Court.
थी ना, वो तो गलत कुरम नजीज होता है ना, गलत अदालत अब चलेगा या उसके पास इख्तियार ही नहीं था टू बिगिन विद, हमारे पास इख्तियार तो था,
So to that
बस
extent,
सिर्फ वो एक प्रैक्टिकल प्रोसीजरल मैटर दैट वुड बी रियली फॉर अस नॉट फॉर द लिटिगेंट, उसको क्या फर्क पड़ना है?
no, I would say, my lord, and that I think to that
I
extent
don't
there
think
has to
that
be
it will
closure.
affect the decided cases. It has become past and closed.
I think that's the only fair conclusion that we can arrive at insofar as.
We're just going to take a short break. Let Khwaja Saab and others, and any other from the petitioner side. I see Mr. Bandari. You are for the petitioner or the?
Your lordships had put various political
No, no.
parties.
Who are you for?
I am for PTI. For one of
Which side of the
No, no,
divide?
I'm supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the
I
Parliament.
would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर
वो भी है, मैं कर दूंगा।
why are you depriving us the pleasure of hearing you?
Very
Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं, तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं, and we'll just come after. We just take a short. I think prayer time is also there. Short break, huh?
And if I may be granted leave, I have to.
As long as you leave somebody here who will
Mr.
know all the
Abdurrahman is
things,
here.
and then if required, submit the. If you think
Yeah,
if you
we
want
have
to,
to
we can't
address
force you to submit a reply.
जी जी हमने questions
But it may be in your interest to do so.
Mr. Attorney General, best wishes from all of us on the assignment they are on. It's in the national interest and it's very important for Pakistan. So best, our best wishes.
My lord, आपने 22 questions मुझसे पूछे हैं जी. You asked me.
आते हैं वापस आते हैं.
नहीं, 22 questions में you like me to ask you to answer now, or you want me to give me some time to
नहीं, अब
answer
जरा
them?
वापस आ जाते हैं, फिर आपको कुछ सुनते हैं, अगर कोई बहुत ही पेचीदा सवाल हुआ फिर हम देखते हैं.
सीधा सवाल तो सारे ही हैं.
But देखिए, petitioner always comes prepared of all the questions कि ये सारे आ सकते हैं. तो वो देखें, other side can say that, but you can't. You are the petitioner.
May I say something?
जी.
That
देखिए ख्वाजा साहब, जरा बात समझने की कोशिश करें ना. the functioning of the Supreme Court has ground
मैं-
stand still.
मुझे-
I don't want that to continue.
मुझे आप इजाजत दीजिए,
ठीक है।
मैं ये 22 सवाल जो हैं, मैं इनका जवाब लिख के आपको दे देता हूँ।
चलिए आप हम वापस तो आते हैं, इनको तो सुनेंगे ना भंडारी साहब को।
सुन लेना।
शायद आप मुतमईन
भंडारी
नहीं
साहब को तो
हैं
मैं-
कि ऐसी जबरदस्त बात करें आप सारे
भंडारी साहब को
तो।
जो है मेरे पास आ चुका है जी। मुझे आप इजाजत इतनी
अभी
दीजिए।
देते हैं, वापस आके देते हैं, देखते हैं, सुने तो कुछ थोड़ी बात।
देखना तो ये है ना
देखते
कि
हैं।
पार्टीज क्या कहती हैं, वो पार्लियामेंट की सुप्रीमेसी चाहती हैं या नहीं चाहती।
सुनकर मौखिक हमने नहीं सुना अभी तक। अच्छा,
थैंक यू
थैंक यू, यू कैन गो देन लीव समवन हियर कॉम्पिटेंट। हाँ, थैंक यू।
ओके, थैंक यू।
नाज़रीन, सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाज